First, according to information in front of us, Congress, when providing funding for immigration and customs enforcement in January this year, Congress imposed the obligation to detain a minimum of 34,000 immigrants each day. I would like to know what is the actual impact of this obligation. Does it mean that the number of detainees each day must be increased? What was the daily average of such detainees last year? And then, most importantly, how is a mandatory quota compatible with Article 9 of the Covenant? Doesn't such a quota create a real risk that certain immigrants will be detained on a given day for the sole purpose of filling the daily quota? Wouldn't such motive amount to arbitrary detention under Article 9?
With respect to your question about bed mandates, U.S. law provides that certain individuals must be detained while their immigration cases proceed before the courts. In support of this statutory requirement, as you noted, Congress funds an average of 34,000 detention beds each day. The Department of Homeland Security has not interpreted this as meaning that each day there must be precisely 34,000 individuals in detention. In fact, that number fluctuates on a daily basis. In fiscal year 2013, the average daily population was 33,788, whereas in fiscal year 2012, the average daily population was over 34,000. It was 34,260. On any given day, 92% of the detention space, these beds, are occupied by individuals subject to mandatory detention.
Second, in your response to issue 19A, you say that the law, and I'm quoting, requires mandatory detention of aliens who have committed certain criminal acts and for those for whom there are reasonable grounds to believe that they have engaged in or are likely to engage in terrorist activities. Certainly, crimes and threats of terrorism are legitimate grounds. But how is it ensured, both at the level of law and in practice, that individuals are detained on the basis of a case-by-case determination? Because that is what Article 9 of the Covenant requires. And also, how can these reasons, crime and terrorism, justify mandatory detention of asylum seekers in general, and not, again, by identifying those who would have that reasons? Can you provide me with more details on mandatory detention of asylum seekers?
U.S. immigration laws provide for mandatory detention during removal proceedings for some categories of criminal and terrorist aliens. Such detention is limited in time by the length of removal proceedings and is for the purpose of ensuring public safety and attendance at scheduled hearings. Release is authorized only in limited circumstances under these laws. With regard to your question regarding the detention of asylum seekers, DHS policy provides that each person who demonstrates a credible fear of persecution will be considered for release from detention with very limited exceptions. And there is indeed a presumption in favor of parole for individuals who demonstrate a credible fear of persecution from the country from which they're fleeing.
Third, regarding limitations on the length of detention, you refer to the Vidas versus Davis decision of the Supreme Court. I must admit, reading Supreme Court decisions is not my favorite pastime, but I had a look at this decision, and I thought that it only applies to detainees with a final order on removal. What about limitation of detention for all the many other cases where there is not yet a final order of removal? Can such persons be detained for unlimited periods until a final order is taken, even if this is taking a very long time?
The U.S. immigration laws provides the government with a general discretionary authority to detain individuals pending a decision on whether or not they should be removed. Persons detained under this general detention authority may be released on bond or on their own recognizance pending removal proceedings if they do not present a danger to persons, property, or a flight risk. Turning to your specific point about the U.S. Supreme Court's case of Zavidas versus the United States involving post-order detention, you may be pleased to learn that the issue of pre-order detention is now the subject of litigation in several courts in the United States. In fact, a limited number of courts have held that the due process requirements of the Constitution require bond hearings for individuals who are subject to mandatory detention under the immigration statute. This litigation is ongoing, so you should stay tuned for the outcome.
Fourth, as regards issue 19b on access to legal counsel and legal assistance, I understand that aliens have the same rights in this regard as U.S. citizens when it comes to criminal charges. As you correctly highlight, and probably there our question was not the really pertinent one, as you highlight, immigrant detention is civil or administrative in character, not criminal. And this then raises the question, how is access to legal counsel and legal assistance ensured in these cases of civil detention, again, at the level of law and in practice? And when I'm referring to practice, how is it ensured in those cases where aliens are removed to detention facilities in more remote areas where the legal profession is underrepresented?
In the United States, non-citizens in removal proceedings have the privilege of being represented by counsel of their choosing at no expense to the government, and the Department of Justice Executive Office for Immigration Review has taken several steps to encourage pro bono legal representation in removal proceedings, including for detained unaccompanied children. For example, the DOJ Executive Office for Immigration Review's Office of Legal Access Programs offers the Legal Orientation Program, working with nonprofit organizations to explain immigration court procedures and basic legal information. The Executive Office for Immigration Review allows accredited representatives who are individuals from recognized nonprofit, religious, charitable, social service, or similar organizations to represent non-citizens in immigration proceedings for a nominal fee, and maintains a list of free legal service providers and private attorneys who have agreed to represent aliens in immigration hearings pro bono. Furthermore, immigration judges are required to assist pro se individuals to the greatest extent possible in immigration proceedings, including ensuring that such respondents are informed of potential forms of relief from deportation or removal and provided with the requisite application forms and submission requirements. In an effort to find efficient and cost-effective ways to improve legal access for detainees in U.S. custody, Immigration and Customs Enforcement partnered with the American Bar Association Commission on Immigration to update the Know Your Rights video. The video is presented in English and Spanish to all detainees in ICE's authorized facilities that hold people for more than 72 hours. The video gives detainees a basic understanding of the immigration removal process. The American Bar Association has also produced, and ICE has distributed, a Know Your Rights guidebook that highlights the topics covered in the video. And then just one final sentence. Access to legal representation is an area that would be improved by passage of the Comprehensive Immigration Bill that passed the Senate last year.
Fifth, moving to immigrant deportation, I'm concerned about mandatory deportation of lawful permanent residents who have not committed grave crimes, but who have been convicted for non-violent misdemeanors. I'm also concerned about mandatory deportation in cases of permanent lawful residents where families are split apart as a consequence of such deportation. And I would like to ask the distinguished delegation to provide further information on the law and the practice regarding deportation in cases of minor crimes, of non-violent misdemeanors. I also would like to ask how mandatory deportation without regard to the individual case, without regard to the personal situation and factors such as proven rehabilitation, health problems, separation of families, and the negative impact on children, and problematic conditions in the country of destination. I would like to ask how mandatory deportation without regard to such factors is compatible with the rights under Articles 17, Article 23, paragraph 1, Article 24, paragraph 1 of the Covenant. All these guarantees require that limitations on these rights must be justified by serious and objective reasons, and this makes, at least in our opinion, a case-by-case determination inevitable.
With regard to the family unity considerations you raised, U.S. law protects family unity and parental involvement wherever possible. In 2013, the Department of Homeland Security established policies and procedures to ensure that immigration enforcement efforts do not unnecessarily impede parental rights of children or legal guardians of minor children who are not citizens of the United States.
Sixth and final issue on this point. I would like to know more about mandatory deportation to countries affected by very serious humanitarian crises, for instance, in the aftermath of a grave natural disaster. How was it justified, for instance, and justifiable to deportations, including some with pre-existing serious health problems and other vulnerabilities, at the time when the effects of the 2010 earthquake and the ensuing grave humanitarian crisis were further compounded by the cholera outbreak? Why did the U.S. deport several individuals back to Haiti under those circumstances, although the Inter-American Commission on Human Rights had issued precautionary measures?
Mr. Kalin's question on deportations to countries affected by serious humanitarian crises. The United States is a leading contributor of humanitarian assistance to victims of natural disaster and conflict around the world. Following the tragic 2010 earthquake in Haiti, which displaced over 1 million people, the U.S. government immediately provided $1.3 billion in humanitarian relief assistance. As of September 30th, 2013, the United States has committed $3.7 billion for Haiti's humanitarian relief. Immediately following the earthquake in Haiti, the Department of Homeland Security halted all removals to Haiti of Haitian nationals with final orders of removal. DHS also designated Haiti for Temporary Protected Status, or TPS. TPS protects from removal eligible individuals from countries designated by the Department of Homeland Security in consultation with the State Department, and those countries currently include Syria as well as Haiti and many other countries. As of September 30th, 2013, For Haitians, the United States subsequently extended temporary protected status, which currently runs until January 2016. So TPS works in increments of sometimes 18 months or longer periods. These protections continue, and approximately 58,000 Haitians have received temporary protected status benefits under this designation. With regard to Haiti, after giving careful consideration to the conditions there, international humanitarian relief and reconstruction efforts, and the need to enforce U.S. immigration law, and after consultation with the government of Haiti, the U.S. government decided to resume removals to Haiti in early 2011. Then and now, the resumption of removals focused primarily on serious offenders. The U.S. government is mindful of the sensitive situation in Haiti and continues to work with the government of Haiti to return Haitian citizens in as safe and humane a manner as possible. Over the past few years, the U.S. government has worked with non-governmental organizations to establish humanitarian procedures for reception and reintegration of these returning individuals. The U.S. government continues to be committed to humanitarian reintegration, working with the Haitian government.
First, I was informed that asylum seekers showing credible fear of persecution will be released. Now, show well-founded fear of persecution is the standard for getting asylum. Does it mean that only once you are granted asylum you can be released?
First of all, I apologize for not being clear with regard to the issue of release from detention of individuals who may be seeking asylum. The process in the United States for those who seek asylum at the border is a two-part process. The first part of the process, an agent or officer will determine whether or not that individual has a fear of return to their home country. That is a much lower standard than actually establishing whether an individual has a well-founded fear of persecution. And it is at that early stage of the process that a determination is made on whether the individual may be eligible for release based on their credible fear that they have expressed.
Second, regarding taking into account family unity in deportation cases, you referred to protecting the interests of families of aliens. What about the case where the deported family member is an alien and the rest of the family are U.S. citizens? To push it a little bit, does mandatory deportation still apply in the case of a foreign husband who is the sole provider for a very sick U.S. wife with small children with U.S. citizenship, who has been convicted for just a misdemeanor that is on the list? Or is this a case where one can look at the individual case?
With regard to your second question on whether enforcement of a law is required for an individual to be returned to their home country if they have family ties here in the United States, I will first say that the U.S. law does not mandate that removal proceedings or deportation proceedings be instituted against anyone who is illegally in the United States. Every day, on multiple occasions, DHS agents and officers exercise prosecutorial discretion on a case-by-case basis. And in fact, in 2011, the Department issued guidance regarding factors to be considered in exercising prosecutorial discretion. Some of these factors include whether the person has ties to the community here in the United States, as well as factors such as whether they have U.S. citizen or permanent residents, children, a spouse, or parents. There are many other factors that are considered, including their contributions to the community, their age, and indeed, if there is some conviction, we look at the nature and severity of the crime, along with many of the other factors that are considered.
Third, I was a bit surprised by the repeated assertion that clearly non-refoulement and extradition is not covered by the covenant. This is not an issue of extraterritorial application. Isn't it obviously inhuman to hand someone over to a foreign state fully knowing that the extradited person will be tortured there? Is it not incompatible with the duty to protect life to deport someone to a country with full knowledge that he or she will be murdered there? Thank you.
Turning to the question of obligations, Mr. Kalin, I just want to make clear that if this was a question raised by my comments, that the United States fully does believe and understands it has non-refoulement obligations. And under Article 3 of the Convention Against Torture, it implements those obligations by regulation. So by no means do I mean to suggest that at the other end of extradition, to ensure that non-refoulement obligations are met, that there is not an interest in ensuring that that takes place. We do have that commitment and we stand by it.